I can't make people be good boyfriends. I can't make people be good girlfriends. It just can't, I can't do that. And I cannot keep him on probation for the rest of his life so that he can be a decent father or a decent boyfriend. Can't do it. He has been violating my order. And when you look at the motion to revoke with him contacting her, you know what people want? They want to remain in relationships with their partner who's abusive, right? Because they love them. But they want the court to make them behave. Complainant Samantha Hayes?
Samantha Rubio.
Samantha Rubio, okay.
Yes, ma'am.
We'll need that corrected. All right, the court is calling 2023 CR 3545 State versus John Thomas Hayes. Can I have parties announced for the record?
Ashley Jones for the state.
Affirmative for the defendant, John Thomas Hayes, Your Honor.
And are you Mr. Hayes?
Yes.
All right, you entered a plea of true to violation of condition number 25, which is contacting the complainant, even though the court ordered no contact. And the court asked for this case to be recalled because the court was informed that the complainant was contacting the defendant. But then there were other issues where people were saying that she only started contacting him after he contacted her. So I want all of this cleared up so that I can make an informed decision on whether to continue him or not continue him. My understanding is that the complainant is here. She's present by Zoom. Can you raise your right hand for me, please?
Yes,
Do you
ma'am.
solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Samantha Rubio.
And were you previously Samantha Hayes?
Yes, ma'am.
All right, any objection to the witness appearing by Zoom, state or the defense?
Not from the state, Your Honor.
No objection for the defendant, Your Honor.
Any questions for the witness?
Not from the state unless you wanted the state to ask,
Yes, if y'all have, because I'm assuming you all are requesting revocation.
actually, Your Honor, I think we were requesting, the,
Continue.
yes, with the mental health, treatment that the probation was recommending. as
All
well.
right, then I have a question.
Okay.
All right, so Ms. Rubio, you understand that I ordered that you're not, that the defendant, Mr. Hayes, is not to have any contact with you?
As of April 8th, yes.
No, I mean, this has been in effect since November 4th, 2024.
No, I was not aware. I was not at the hearing. I was only told on April 8th.
So you're telling me up until April 8th, you didn't know you were not supposed to have contact with him? Well,
I
I'm
knew there
sorry,
was-
I have no jurisdiction over you, but you're telling me that in April 8th, you just discovered that he's not supposed to have contact with you.
Yes, because I asked I think it was Marina when I spoke to her, what the conditions were. I was just aware that he was going to a health facility and he had 6 years probation because every time she contacted me, I was at work.
No, well, see, here's my thing. You're saying that you don't know that he's not supposed to have contact with you. And then I have a motion to revoke because he's constantly contacting you.
Again, on April 8th, when she told me there was a no contact because I asked what the conditions were, that's when I told her that he had contacted me.
All right, so here's the thing. You know you're not supposed to have contact with her. I don't know why you should remain on probation because my orders are very simple. My orders are no contact. Is there something somebody can explain to me then? Why doesn't he know that he's not supposed to have contact with her? Because it clearly states on his conditions, he's to have no contact with her. So whether she's contacting him or not, he knows he's not supposed to have contact with her.
There is a child involved, Your Honor. There's a 3-year-old child involved
Yeah.
that they have a child together.
I understand that, but I told him no contact. And I always tell people when you have a child, guess what? You're going to have to go through a third party because we're here for a violation of bond protective order assault. So because you're here for a violation of bond or protective order, you know what that means? There have been previous orders that are in place that you have violated where a court has told you you're not to have contact with her. If there were not any previous violations, guess what? You wouldn't be in felony court for violation of bond or protective order. So I don't know if he's appropriate to be continued. I know the state is saying we want him continued. Probation may be saying you want him continued, but it appears that he doesn't understand what no contact means.
Your Honor, I want the court to consider the fact that Mr. Hayes has mental health issues. He has, initially, I was not the attorney at the time, but initially, apparently, he was deemed incompetent, and so he had to regain competency. And in that time period, apparently, he has been in custody 782 days, almost 2 years, more than 2 years. So if the court is gonna revoke Mr. Hayes, I just want the court to consider that and consider the record that he shows that he has mental health issues.
Okay, because I just don't, nobody has given me any reason why he shouldn't be revoked, because he's here for a violation of protective order, which means that a protective order has been placed and he's continued to violate it. That's why we're here. Otherwise, you wouldn't be in felony court. When a court orders no contact, that's what it means. This whole thing, the complainant is saying she didn't know she wasn't supposed to have contact. She did. And let me just tell you why I believe she did.
Maeve, can I say something?
No, you cannot. Let me tell you why I believe she knew she was not supposed to have contact. Because there's an order in place before they even got to this court that says he's not supposed to have any contact. So that means somebody had to go to court. And usually when they have on the civil side, these orders about no contact, the complainant is usually there and there's usually a representative for complainant. Normally, the person who has the protective order against them, usually they're not there, or either they waive or parties agree, you know what? We're just not going to have any contact with each other. So everybody knew there was supposed to be no contact. So when people come here saying they didn't know, they knew, because that's why we're here in the first place, because you previously violated a protective order. So there we are.
My understanding of
Why
protect,
should I revoke him?
And Your Honor, if the state could just speak in, speaking with the complainant, I'm happy to ask the complainant now since I have her. But in speaking with the complainant, we did discuss the options involving this motion to revoke probation. My understanding from our conversation was that she wanted him on supervision as long as possible and to get treatment rather than just go to prison with no treatment, him get out and then still
Well,
have.
here's the thing. He can get treatment as prison. This is what I don't think people understand. What I've learned from these cases that involve violence, and I understand the circle of violence, I understand all of that. 9 times out of 10, from my experience as a prosecutor and a defense attorney, you know what people want? They want to remain in relationships with their partner who's abusive, right? Because they love them, but they want the court to make them behave. I can't make people be good boyfriends. I can't make people be good girlfriends. It just can't, I can't do that. And I cannot keep him on probation for the rest of his life so that he can be a decent father or a decent boyfriend. Can't do it. He has been violating my order. And when you look at the motion to revoke with him contacting her, it's March 20th, March 16th, February 14th, February 4th, February 2nd, January 25th, January 21st, January 19th, January 18th, January 12th, January 11th. Telephone, mail, or in person. I can't make people be good partners for people. I don't have that authority. Either people want to be a good partner or they don't. I know that's what people would love, for this to be a family unit, for he to be in your life, for y'all to be a happy, loving family, and for him to be a good father. But I don't have any control over that. I don't think he's a good candidate. I don't know how many times I have to tell that. I mean, that's the number one thing. Report, no contact. Whether she knew it or not, which I think she knew, he's not supposed to have contact. And if I were to continue him, you know what's going to end up happening? He's going to get released. They're going to have contact. She going to call him. Then he's going to come to me. And whoever's attorney is going to say, well, she's the one who contacted him. And this relationship is not going to work. So I don't think he should be continued. Is there a trial court certification?
Yes, we did sign one.
All right, let me
First
see.
time.
Do you all want to agree on a time?
Your Honor, if we can have just a moment to confer.
Sure.
Thank you, Judge. And so at this time, the state would offer Exhibit 1, pending any objection from defense.
Any objection?
No objection.
All right, the court will accept into evidence. State's exhibit number 1. All right, did you have a chance to see that?
Yes.
All right,
And Your Honor, at this time, the state would be asking for 6 years.
Your Honor, we're asking for 4 years, Your Honor. Mr. Hayes admits what he did was wrong. However, Mrs. Rubio was intoxicated at the time. Just like he claimed, she found her posting with that she made in to Mr. Hayes that it was her fault. She was intoxicated when she made the communication with Mr. Hayes. So just as those times that she was intoxicated that time, and I want the court to consider that. Mr. Hayes, he's never been to prison. He's never ever had any other problems with the law, Your Honor. So we're asking for the court to consider punishment at the lower end of the range, Your Honor, of the punishment range.
all right, this court is going to do, as previously stated, the court is going to find you guilty. The court is going to revoke. There's to be no contact with Samantha Hayes or Samantha Rubio. The court will order the therapeutic community. Court will sentence you to 6 years in the prison, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, oh, I'm so sorry. Could I have that back? I didn't check the appropriate box for you.
Your Honor,
Yes,
he's already completed lifetime recovery, the inpatient,
okay.
completed last year, I believe. No,
90 days.
90 days.
All right, I'll give him credit for any time served in inpatient treatment that was successfully completed. And for the record, the court will note that the lifetime recovery was successfully completed. Again, with the trial court certification, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion and not the fact that you were on deferred adjudication. There is an affirmative finding of family violence. Again, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. And it's also because this is an affirmative finding of family violence. Do you understand?
Yes, sir.
All right, we can go off the record. I'm ordering the therapeutic community for you. With regards to the therapeutic community, I have no jurisdiction to have them place you in that program, but they'll see that I'm recommending it, and you'll need to request it as well. You understand? All right, good luck to you.
Yes, Your Honor. I'm standing in for Mr. Lyles. Mr. Newkirk is in agreement with that, and Mr. Lyles has received and reviewed all discovery with him.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Newkirk, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
And I'll take up the motion to revoke after this.
Thank you.
Mr. Newkirk, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
I did, ma'am.
Did you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I do.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you just 1 second.
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Newkirk, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Not at all, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Very much so, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 180 days in the state jail facility. The state will take in consideration 2024 CR 010664, 2024 CC 738030, night mag number 767200. This is run concurrent with 2019 CR 13070, 2024 CC 738034. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I did, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense, how do you plead?
Guilty, ma'am.
State any evidence.
Contained in Exhibit 1 and attachments, Judge.
No objections.
Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
I did, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence. The court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor. Well, I guess just, he was in the Marine Corps for 8 years, 4 deployments, diagnosed with PTSD. We're hoping that once he has enough time, I believe that he'll be out fairly soon if the court allows this plea to go through and the motion to adjudicate. But he has already looked into a program in Houston for combat veterans with PTSD. And so we're just asking the court to follow that agreement.
All right, the court will follow your agreement, sentence you to 180 days in the state jail facility, give you credit for any time served. This will run concurrent with 2019 CR 13070, 2024 2024 CC 738034, taking consideration 2024 CR 010664, 2024 CC 730. All right, 2024 CC 738030, night mag number 767200, and the court will request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Going to proceed with 2019 CR 13070. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
I did, ma'am.
Are you the same Dustin Chapman Newkirk who was placed on deferred adjudication in 2019 CR 13070 for the offense of possession of a controlled substance penalty group 1, less than 1 gram on August 13, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
State?
On or about the 26th day of October 2023 in Bexar County, Texas, the defendant Dustin Chapman Newkirk did then and there fail to register for the parenting class in violation of condition number 20.
How do you plead to that? True or not true?
True.
State waives the remaining violation allegations.
Any objection?
No objection.
Did you understand by pleading true to a violation of condition number 20, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility, and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 20?
I do, ma'am.
Court will find violation of condition number 20 true. Is there a proposed agreement?
Yes, Judge, adjudicate guilt, revoke supervision. Thus punishment at 180 days of confinement in the state jail facility running concurrent with 2024 CR 010665.
That's correct, Your Honor.
All right, probation. Has Mr. Newkirk completed anything while on probation? And did he pay restitution?
Your first question, and I don't have any restitution order.
Okay. All right, you haven't done anything on probation. I understand that people have different issues that they're going on in their life. That's why I ordered certain conditions for you.
Yes, ma'am.
This is what the court is going to do. Court is going to find you guilty, revoke. This will run concurrent with 2024 CR 010665. There's to be no contact with Victor Phillips or Megan Louder. There is to be the therapeutic community, and the court is going to sentence you to 300 days in the state jail facility. Give you credit for any time served. Court is going to recommend the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Your Honor, just, he was confused. The individuals that were named, was that in the original plea bargain, I'm assuming?
Yes.
Okay, because it was a less than a gram case. Is there a way to see it so I can just show Mr. Newkirk?
Sure.
Thank you, Judge.
Judge, may I approach?
Yes. I'm sure that was due to something else being taken in consideration.
Oh,
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
yes, ma'am.
You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you will need to speak to an attorney. Do you understand?
Yes, ma'am.
All right. We can go off the record. When you're released from custody, if you can't find a place that will help you with whatever issues you may have, if I'm still here, you can come.
Send it to the court, Your Honor.
Yes, thank you. Court is calling 2020 CR 2212 State versus Victoria Castro Villarreal. Can I have parties announce?
Andrew Harris Edelman for the state.
Renee Munoz on behalf of the defendant.
And are you Miss Villarreal?
Yes.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Victoria Castro Villarreal who was placed on deferred adjudication in 2020 CR 2212 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on July 2nd, 2020 for a term of 4 years? Is that you? All right, state.
In Bear and or DeWitt County, Texas, the defendant Victoria Castro Villarreal did then and there fail to report to the supervision officer as directed for the months of April, May, June, July, August, September, October, and November 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True.
State waives the remaining violation allegations, Judge.
No objection to the state waiving the remaining conditions.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5? All right, you're whispering.
Yes, ma'am.
Court is finding violation of condition number 5 true. Is there a proposed agreement?
I believe so, to adjudicate and sentence to 2 years TDC.
That is our understanding of the recommendation to the court, Your Honor.
What has she done on probation?
She has not reoffended, not picked up any new offenses, ever since this possession charge, Judge. In relation to her criminal history, this possession charge is the only thing she ever had. She may have bit off more than she can do in terms of the supervision. There was some issues with family that caused her to be somewhat homeless, mom losing the apartment that they were in, not affording her the opportunity to check in. And she was scared at that moment and just kind of just didn't check in because she thought she was going to get picked up at that point in time, shortly after the issues with the family home. So she just didn't check in, Judge. But in reference to this charge and to the decision before the court, we asked the court to look at the charge which is on probation for, she was on probation for, which is possession of controlled substance. It's a nonviolent offense. There are no victims other than the state of Texas and her doing this to herself in terms of the drug usage and the wear and tear on her body, Judge. She has 4 granddaughters. She wants to be there for them, to look over them. She has explained that she currently does not suffer from using substances in terms of addictions, but at the time of this offense, she was dealing with that. I went back to the original case and looked at the circumstances of that case, and it seems like the officer had seen a straw pop out of her pocket and there was some residue on it, which led them to uncovering some methamphetamine in her purse. Although it is classified as a second-degree offense, Judge, it was more or less around the 4-gram range. I think it was like 4.3 grams. So I know that's a large range, the 4 to 200, but we're in the bottom range of that, Judge. So I went over the options with my clients, notified her that staying on probation was going to be a stretch because of the amount of time that she had not checked in. But we're just asking for the honorable court to sentence her in reference to the offense, which is the possession charge. We know that she didn't do much of anything on probation, but she did stay out of trouble and did not pick up any new offenses ever since this 2020 offense, Judge. So this would be the first felony conviction for her and the first time for her going into prison. So being that that's the case and the circumstances, Your Honor, we're asking that the court honorably enter into the 2-year recommendation. I did notify my client that the recommendation is not binding on the court, but I told her I would offer this mitigation to the court so we can get a better look that she's not a career criminal or threat to the community or society.
All right, I have some questions for you. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Castro.
All right, so did you complete intensive outpatient treatment with probation?
No, that's outpatient.
No,
Did you provide proof of employment?
no, I didn't do transport. I'm working.
I'm sorry?
We went, because my mom had to get out of her house. So we had to move to Clarence County.
All right, so how old are you?
Before.
All right, so you're 40. You're depending on your mom to support you, and
That's when I
because,
first got out. I was trying to get back on my feet.
okay,
Literally, I did, they didn't get on, like the RV, on the property, and have like a little RV.
all right, so let me just tell you my issues with you. My issues are that we were here previously before for your not reporting. And you continue to not report. Reporting is the easiest thing to do on probation. All you have to do is report, and you didn't. That's a problem. And I don't know if you're clean or not clean.
Well, I like to got my granddaughters, because my son, I lost my kid's GPS, but my two, I got my children back, they aged out.
Mhm.
I'm not gonna leave my grandkids on something stupid like I did.
Well, here's the thing. You're saying you're not going to lose your grandchildren. You are. You're about to go to prison.
Now I have no choice, but I have to know drugs.
I think the issue, Judge, if I may interject, and I apologize to the court for this, is that the time she was dealing with these issues of non-reporting, she was also seemingly dealing with her addiction issues. And I just feel that maybe after SATIF, which she did complete, Judge, that maybe some more intensive care would have been in line, but I feel like she was still struggling with those issues, which made reporting a little difficult for her, and she probably was fearful. But I've explained to her sometimes, a lot of the times we have to face our fears because if not, they're eventually going to catch up with us, and it's going to be much more detrimental to our future than just facing up to the fear. And she's taken responsibility and accountability, Judge. She knows what she did was not correct. We're not asking that she be continue on probation. We understand the court wants to adjudicate her, but we're asking that the term of years is on the lower end as she's first time going to prison, first time being a convicted felon, and not reoffending, Judge.
Probation, has she done anything on probation?
Judge, she completed 119 days in Saturday.
All right.
She was working on it, Judge.
All right, this is what the court is going to do. The court is going to find you guilty. The court will revoke. The court will sentence you to 5 years in the prison, give you credit for any time served, request the therapeutic community. There's $1,000 fine, time and money to run concurrent. There's to be no unsupervised contact with minors, credit for any time served in SATA. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Obviously, you have a drug problem. When you are released from prison, if you cannot find a place to go, if I'm still here, you come back here, I'll pick up the phone, call, so you can get in a place so you can maintain your sobriety. Because when you don't, one or two things gonna end up happening. Either you're gonna go down this line where you're gonna constantly be in and out of jail, in and out of prison, or either you're gonna get some bad drugs and somebody's gonna have to identify your body. And usually the person they have identify the body is a family member. So it's gonna, maybe your mom, maybe your children, maybe your grandchildren. You understand? All right, good luck to you.
May we go on the record briefly
Yes.
so I can state the SATA dates upon her completion?
Yes.
As per the probation's court summary and also verification, like
In this powerful courtroom moment, Victoria Castro Villarreal stands before the court after admitting she failed to report to probation for 8 straight months. Originally placed on deferred adjudication for possession of a controlled substance, 4 to 200 grams, she faced up to 20 years in prison after pleading true to the violation. Her attorney argued she stayed out of new trouble, struggled with homelessness and addiction, and asked the court to follow a 2-year recommendation. But the judge focused on one key issue. Reporting is the easiest condition of probation, and she repeatedly failed to do it. At 40 years old, still dependent on her mother, and without completing required treatment or employment verification, the court found accountability lacking. Instead of the recommended 2 years, meant the judge sentenced her to 5 years in prison, a $1,000 fine, and ordered therapeutic community placement. The final warning was stark. Without sobriety, the path leads either back to prison or to something far worse. Do you think 5 years was justified for failing to report? Comment below, and don't forget to like and share for more real courtroom breakdowns.